Good afternoon and welcome. Before we begin, there's so much going on here in the Twin Cities, including the tragic death of another unarmed Black man at the hands of the police. And I want us to take a moment to have a remembrance of Mr. Wright. So if you all will indulge me in a moment of silence to do that, I would appreciate it. So please join me in a moment of silence. Thank you. So I'm Gary Jenkins. I am the Dean of the Law School. And I want to thank you all today for joining us to discuss Judge Jed Rakoff's book. As you all know, Judge Rakoff is from the U.S. District Court of the Southern District of New York, and his new book is entitled Why the Innocent Plead Guilty and the Guilty Go Free, and Other Paradoxes of Our Broken Legal System. This discussion is moderated by our own Professor Francis Shen, and so it's really going to be an important afternoon discussion. But before we begin, I want to give a special thanks to Professor Claire Hill and her Institute for Law and Rationality for bringing this event to the law school. The Institute for Law and Rationality promotes interdisciplinary collaborations between legal scholars and those in fields that address human behavior and attempts to ground those in public policy. And Professor Hill has done us a great favor today in bringing an esteemed federal judge to us. The vast racial and economic disparities between arrests, conviction, legal representation, sentencing, parole, and many, many other areas of the legal system continue to mirror the inequalities in society. And as we are all aware, perhaps especially so for those of us here in the Twin Cities and in this moment, the structural injustices and inequalities in our country are reflected in and connected to our legal system. Here at Minnesota Law, we must listen, learn, and think about the ways that our systems actually work and how they should work. As we engage in our core mission, right, which is focused on education and scholarship and engagement, we seek to better understand and educate and represent others and lead change that will dismantle barriers to justice. And today, we are honored to host this discussion between an esteemed federal judge who has noted that our country's system of justice is failing in its mission, and Professor Shen. As I mentioned, Professor Shen is our moderator. He is a McKnight Presidential Fellow here at the university. In addition to his primary appointment, of course, here at the law school, he's also a faculty member in the graduate program in neuroscience. And externally, he is the executive director of the Center for Law, Brain, and Behavior at Massachusetts General Hospital at Harvard. Now, those of you who have taken classes with Professor Shen know that he's an engaging educator and an impactful mentor. His teaching, his scholarship focuses on empirical and interdisciplinary questions related to the intersection of law and the brain sciences. He's the co-author of the first Law and Neuroscience casebook, and just last month, he received the American Law Institute's Early Career Scholars Medal for being a pioneer in establishing the interdisciplinary field of law and neuroscience. So thank you, Professor Shen, for moderating today. And of course, he'll be in discussion with Jed Rakoff, who is, simply put, a towering figure in our profession. Thanks to his 25 years on the bench, 52 years in law. Prior to being appointed to the bench, Judge Rakoff clerked on the U.S. Court of Appeals for the Third Circuit, served as a federal prosecutor in the U.S. Attorney's Office for the Southern District of New York, and practiced at 3 large New York law firms. He has served on the district court, as I mentioned, the Southern District of New York, since 1996. And has frequently sat by designation on the 2nd, 3rd, and 9th Circuit Court of Appeals. In addition, he's authored more than 1,500 judicial opinions, 5 books, and 150 articles. He is also a regular contributor to the New York Review of Books. He's a member of the American Academy of Arts and Sciences and the American Law Institute. Now, the students know that I talk a lot about what it means to be a lawyer leader. Well, Fortune magazine named Judge Rakoff to its list of the world's 50 greatest leaders in 2014. So we have a living lawyer leader right here. Now, before I turn it over and we begin, a few housekeeping notes. Today's webinar is being recorded, and the link of the recording will be shared via email following the event. We have the live auto captioning enabled, so please click on the live transcript feature at the bottom of your Zoom screen if you want to view or hide the captions, as is your preference. We will reserve time at the end for the judge to address questions submitted via the Q&A function, that feature that's found at the bottom of your Zoom screen. Professor Shen will check the Q&A, and he's going to pose your questions as well as his own to the judge. So with that, even though we're virtual, please join me in a warm welcome, a warm Minnesota law welcome to Judge Rakoff. Thank you so much, Judge, for joining us.
Thank you so much for that extremely kind introduction. I'm just glad that my wife hasn't tuned into this program, because she would now demand rebuttal time. But it is a pleasure to be here. I've had the great privilege of visiting at the University of Minnesota Law School on several occasions, and it's just a wonderful place. It is a little sadly ironic to be speaking on this day when another tragedy has occurred, and much of what I'm going to talk about are broader but also very serious problems in our legal system. But I want to say at the outset, they're all fixable. No one should be a despondent pessimist. We can overcome all these problems, and I will try to suggest a few ways that the problems I will focus on can be overcome. But let me start with the most obvious problem, one that I'm sure is known to most people who are listening, and that is mass incarceration. So the United States locks up about 2 million people every year. Putting that in perspective, United States is 5% of the world's population. We incarcerate 25% of all the people in jail or prisons in the world. I remember when I was growing up, we used to be so proud to say the United States is number one in steel or cars or whatever. Now, I'm afraid we have to say we are number one in incarceration. And it is not only shameful in itself, but it comes against a background where since 1996, there have been steadily declining crime rates. There's a little blip this past year because of the pandemic, but other than that, even now with the blip, crime rates are at a very low level in the United States compared to where they were in the 1980s, 90s, and so forth. And yet, the incarceration has not decreased. There's been a very small decrease this year, but overall, there's been an average of 2+ million people locked up every single year since the year 2000, which means that we're locking up an ever higher percentage of those who are accused and locking them up for longer and longer periods of time. There is also inevitably a racial aspect to this. 40% of the 2 million people in jails and prisons in the United States are young black males between the ages of 18 and 34. Another 20% are young Hispanic males. At the prime of their young lives, they're being taken away from their families, from their communities, from their children, from everyone with whom they had a relationship, and thrust into prison where, frankly, they will become more hardened and more and less likely to be good citizens. How did this all come about? Because it wasn't the case always. In fact, in 1960, the total number of people in jails and prisons in the United States was about 300,000, a tiny fraction of what it is now. Well, in the late 60s and on through to the early 90s, crime rates in the United States were rising significantly, and this probably inevitably gave rise to a political reaction where there were imposed very, very harsh laws, mandatory minimums, often going up to 20, 30, 40, even 45 years, career offender statutes, which led to lifetime incarceration, sentencing guidelines that were originally and for their first 15 years mandatory, that got ever harsher every year, usually at the behest of Congress. And it was this that drove mass incarceration. But there were some other very negative side effects of all this. One was the total end of jury trials, because when you were facing mandatory minimums that were so harsh and so huge, and which the judge had no power to change, the best thing your lawyer could do for you is plea bargain to a lesser amount of time. And so the number of cases going to trial changed from about 20% of federal cases and 25% of state cases as of 1980 to 3% of federal cases and 2% of state cases, and that's where it's been for the last decade and more. And I can remember as a criminal defense lawyer, I was first a prosecutor and then for 15 years a criminal defense lawyer. Often that was really the best thing you could do for your client was a plea bargain. But of course, trials are where the system gets subject to public scrutiny, where it gets tested. Plea bargains are secret negotiations in the back rooms of prosecutors' offices, and there's really no scrutiny at all. And this leads to what maybe is, to me, the most upsetting thing, which is that a great many innocent people are pleading guilty to crimes that they never committed. And that's because they can't take the risk of going to trial, because if they are convicted, they will face such harsh prison terms that they would rather plea bargain to a much lower term than take that risk, even if they're actually innocent. And we have some pretty good statistics on this. The Innocence Project, which has used DNA to exonerate now more than 370 people, mostly of the most serious crimes, rapes and murders, reports that 10% of those 370 pled guilty to crimes that they had absolutely nothing to do with. And worse yet, the National Registry of Exonerations, which a number of law schools have put together, which records every court-ordered exoneration since 1989 and is now up to about 2,400, reports that as much as 15, maybe even 20% of the people there pled guilty to crimes they never committed. Now, you can't extrapolate those statistics immediately to the entire population. In the case of the Innocence Project, probably a number of those people pled guilty because they were facing the death penalty, so there was unusual pressure to plead guilty. In the case of the broader National Registry statistics, some of those included fairly minor crimes where there really was not much loss from pleading guilty. But even if we assume that it's not 15 or 20%, that it's not 10%, that it's only very conservatively 5%, that means that 100,000 people presently in jail or prison are there because they pled guilty or are about to plead guilty to crimes that they never actually committed. And I think that is outrageous and unacceptable. Now, one other point I should make is that even those people who were innocent, who did go to trial, were frequently convicted. That's the other 80 or 90% of the exoneration statistics. And why were they convicted even though they were actually innocent? Well, the two biggest factors were improper forensic evidence and inaccurate eyewitness testimony. The forensic evidence was pretty much exposed in a report issued in 2009 by the National Academies of Science, which showed that putting aside DNA, most forensic evidence, bite marks, tool marks, hair matching, and all like that, has never been scientifically tested and is frequently inaccurate, and in fact is highly subjective. The FBI was sufficiently disturbed when it learned that as a result of these exonerations, a number of cases in which its experts had said that there was a hair match, that is to say that hair found at the scene of the crime matched, according to their experts, the defendant's hair and no other person's in the world, that those people were then shown by DNA to be actually innocent. So the FBI did a study of the 3,000 cases in which its experts had said there was a hair match, And they concluded that that testimony was either flat wrong or at a minimum materially overstated in 95% of those cases. 95%, just amazing. What about eyewitness testimony? Bad forensic testimony is present in about 40% of the exoneration cases, but inaccurate eyewitness testimony, according to the Innocence Project, is present in 70% of those cases. By the way, if you notice that adds up to more than 100%, it's because some of those cases had both inaccurate eyewitness testimony and inaccurate forensic testimony. But why is eyewitness testimony so inaccurate? Most commonly, it's because of frailties in the human memory and perception equipment that are very difficult to change and yet are not recognized by most everyday people. And were really only brought to attention by scientific studies that have been done over the last 2 decades that are summarized in another report of the National Academy of Science that came out in 2014. And what that study showed was, just to give 2 examples, first, there is a racial aspect. People of one race are much less good at discerning the fine features of a face of someone of another race than of people of their own race. So whites are very poor at discerning the fine facial features of blacks. Blacks are very poor at perceiving the fine facial features of whites. And people don't recognize this consciously, but it's a well-established fact. And when you consider that many eyewitnesses only see the face of the perpetrator of the crime for a minute or two, and they may be more focused on his weapon than on the face itself, you can see how this can have devastating consequences. A second example is the so-called merger effect. So an eyewitness witnesses a crime. He sees the face of the perpetrator for a few minutes at best. And if you could take a photo of his brain at that point, you would see that he has only a vague picture of the person he saw perpetrate the crime. But a few hours later, he is shown a photo array by the police. Sometimes it's a lineup, but usually these days it's a photo array, 6 or 7 photographs, all roughly similar to make sure that there's no bias. And he's asked whether there's anyone there who he saw commit the crime. And now he will study those photos very carefully. And he'll notice for the first time that maybe one of them has a scar above his right eyebrow. Now, that person also is the person he thinks maybe is the one, he's not sure, but maybe is the one most like the person he saw commit the crime. So he will say something like, I think it's number 2. 3 months later, when he talks to the prosecutor, or a year later, if the case does go to trial, he will be absolutely sure that he saw at the time of the crime a person with a scar above his right eyebrow. Those 2 memories unconsciously will have merged. He's completely unaware of this merger, but now he feels absolutely sure in his mind and memory, yes, the person I saw, that was a person with a scar above his right eyebrow. And so he will now be sure it's number 2. And of course, many times it's not number 2. Without multiplying examples, I want to shift to 2 other quick problems in our legal system. The first is the utter failure to prosecute high-level executives for often very, very serious crimes. It's no surprise that law in the United States, like law in many societies, treats the poor differently from the rich. And the poor in the United States are treated very harshly. The rich are basically exempt from prosecution, at least if they're high-level corporate executives. This was not always true. Throughout most of the 20th century, the prosecutors went after high-level executives, often with great success. The CEOs of Enron, the CEOs of WorldCom, the CEO of Tyco, and so forth down the list were all successfully prosecuted. But around 2006 or so, this began to change, and it was mainly a change as a result of limited resources. And it was realized that particularly under federal law, the crimes of even very low-level people could be imputed to the entire corporation. And so the corporation was dead in the water. And so it's easy to go after the corporation and get a big fine, $1 billion fine that could be announced in a big press conference with a lot of falderall. And maybe there would be some compliance measures thrown in to allegedly prevent future recidivism. And you didn't have to spend the very long time and substantial resources that would be necessary to go after the individuals who actually committed the crime or who permitted it to be committed on their watch. To my mind, this is a terrible thing. Corporations don't abstractly commit crimes, individuals do. And when we're talking about big financial crimes, it's often at the highest levels. And instead, to go after the corporation is to ignore the people who actually committed the crime and should be brought to justice. And the final problem I want to bring to your attention is the increasing failure of our system to provide lawyers for even everyday folks with everyday problems. Forget about the criminal justice system. I'm talking now about working class people who maybe are going through a divorce or custody battle in family court, or going through a mortgage foreclosure in housing court. The statistics from all the states put together are that whereas 50 years ago, almost all the individuals who were named either as plaintiffs or defendants in cases in those courts had a lawyer, now over 2/3 do not have a lawyer, and in some states it's as high as 90% without a lawyer. And chiefly that's because lawyers have become too expensive. Lawyers' rates have risen at 3 times the inflation rate over the last few decades. They have priced themselves out of the market. They're becoming ever more specialized, and they can get paid by big companies and the like, and they don't need to cater to everyday folks. But the result is devastating. It's the same statistics show that if you have a lawyer in housing court or family court, you do pretty well about half the time. If you don't have a lawyer, you only succeed less than 10% of the time. So it makes a huge difference. Now, having painted this very glum picture of the legal system, I promised you that there were solutions, and I hope that will be one of Francis's first questions, because I told him I wouldn't go more than about 20 minutes, and I think I've done that. But I do have some solutions to suggest we are not without hope. Meantime, though, our system as it presently exists, I'm afraid, is seriously broken. Thank you very much.
Thank you, Judge Rakoff. What a wonderful set of remarks, and I'm looking forward to our discussion. As we get into it, let me just remind everyone in the audience that we would like you to participate as well. And as Dean Jenkins mentioned, the way to do that is through the Q&A function down there at the bottom of your Zoom screen. I have a number of questions, and we'll get into a discussion, but we'd love to incorporate your questions and comments as well. So keep them coming, and I'll monitor that. We'll work them into the discussion. Also, if you haven't purchased it already, I don't think we've actually held up the book, but we should. Why the Innocent Plead Guilty and the Guilty Go Free, and Other Paradoxes of Our Broken Legal System. And I want to start with that word paradox, Judge Rakoff. I know that you're a fan of musicals, as am I. So let me quote Gilbert and Sullivan, Pirates of Penzance, a paradox, a most ingenious paradox. And there's this great line, how quaint the ways of paradox, at common sense she gaily mocks. So much of what you write in this book and what you point out, and including what you've just mentioned, just sort of seems to fly in the face of common sense. And the thing I want to ask first is, in fact, what's remarkable to me is that you've written this book at all. And I say that because, with the exception of just a few judges, some of whom you mentioned at the outset and who've spoken here at the law school, Judge Mark Bennett, formerly on the bench, and Judge Nancy Gertner, formerly on the bench, very few judges speak out, which is, to me, in itself a paradox, because you're an Article III judge, you have life tenure. I mean, who could be more powerful than a judge? And yet the picture painted in your book is almost one, now I know we'll get to some solutions, but of one of judges who just go along, who try not to get overturned. I found one quote from an article that was written about you. You were reported as saying, so I assume you said it, if you're never reversed on appeal, you probably have taken too narrow a view of the law. So I'm wondering if you could say a little bit about, why are you speaking out, and why don't we have, a series where we have 100 judges, whether it's a book or an article, writing the same thing? Because they must be seeing the same things you are, these things that belie common sense, and yet there's radio silence. So why are you speaking, and why is it so rare that we hear judges speaking out on these issues?
So thank you for that question. I think it's because judges believe that they should remain above the fray in order to maintain public confidence in their neutrality. And that's certainly not without some justification. And for the first 14 years on the bench, that was really sort of my view. The public needs to view judges not as politicians with ideological stances, but as someone who is neutrally applying the law. But then I began to see more and more systemic problems in the very system that I was administering. So then I went back and looked at the canons of conduct of the federal judges, which bind all judges except, by the way, the Supreme Court, which is not bound by them. But there in the canon, in the code of conduct, it expressly says that judges may speak out on matters involving the due administration of justice. And in the commentary to the same code, it says judges are encouraged to speak out about problems they see in the due administration of justice for the very reason you just mentioned, that who knows it better than we see it every day. And so that's when I first began writing, and now trying to reach a larger audience with this book. But notwithstanding the permission and even encouragement of the code of conduct, the fact of the matter is that most judges sort of instinctively feel, as I did for many years, that's not our department. We should remain silent.
Yeah, so let me pick up on that, and I do want to get to some of the solutions you offer. One of them is to recognize, I think, that although there ought to be more jury trials, and maybe there will be, there's still going to be a lot of plea bargaining. And so you have some solutions that I think recognize the reality of the plea bargaining system that we have, and that at least for the foreseeable future we'll be sticking with. One of them is to insert a judge, a magistrate judge, into what typically is just prosecution and defense negotiation as a neutral. And therefore, as you say, this neutral third party, and they would have to appear with them. They don't have to listen to what the magistrate suggests, but it changes the dynamic. Could you say a little more about that? And I guess a concern is that a double concern is precisely for the reasons you've just mentioned. Judges have not, there's just the culture is not to get involved at that level. Is there a concern that that there could be some unintended consequences? And in particular, I'm thinking, as you discuss, of how the sentencing guidelines were initially proposed, I think by those who had some good ideas in mind, which is let's eliminate disparities. And here is a wonderful motivation to, reduce mass incarceration. Is there a chance that this could go awry as well? And how would you guard against that?
So there are some dangers, and that's why federal law prohibits involvement of judges in plea bargaining. The states are more divided. About a dozen allow it, about a dozen prohibit it, and the rest are silent, and a judge has freedom to go either way, so to speak. So there have been some experiments with this, in my view, very positive on the whole, but there are dangers. That the reason the federal law says judges should be involved in plea bargaining is the notion the judge, again, should be above all this. If the parties reach a plea bargain, that's great. If not, the judge will be totally unaffected when the case goes to trial. Of course, in practice, this means that judges are not involved in what constitutes 97% of the federal system and 98% of the state system. So we're playing a trivial role as a statistical matter. And you talk about disparities. There are hard prosecutors and soft prosecutors, often in the same office, and they will turn out totally different plea bargains for essentially the same crime. And no one will ever know those disparities because it's all done in secret. So my proposal, which builds on what is done to some extent in both Connecticut and Florida, is that a judge other than the judge who will try the case will meet immediately after indictment with the prosecutor and separately the defense counsel. These will be recorded meetings but sealed, so neither side will know what the other side was saying. But it'll be recorded to make sure that nothing improper was ever said. And the judge will get its chance to see what the prosecutor's proof is. We'll get a chance to see what the defendant's defenses are, and can make recommendations, which the parties are free not to follow, but I think will follow. Well, how come it looks like everything turns in that eyewitness? Maybe you should have gone over and looked at the other suspect who was originally implicated, or on the defense side, have you hired an investigator? Your guy says he was not in the area. Surely there's maybe some witnesses that a good investigator will be able to turn up who saw him at that other location, et cetera, et cetera. And Then, after meeting with them and discussing the case with them, after a while, the judge will say, I think this case should be dropped, or I think this case should be plea bargain, but at such and such a level, or, I think the case really should go to trial. And none of that will be binding on the parties, but again, coming from a party who doesn't have an axe to grind, the judge, I think it will be taken very seriously and adopted as it has been in those two states that sort of do this. And I think that will result in much fairer plea bargains, fewer innocent people pleading guilty, and a general cleansing of a system that is now so secret and unsubject to judicial scrutiny.
It's an interesting proposal, and also interesting is a proposal that you attached to that, which is to have prosecutors spend some of their time working in criminal defense. It'd be in a different jurisdiction. I was struck by this because, increasingly my diagnosis is that there is a prosecutorial culture that envelops line attorneys as they move up. And as you suggest, the sort of statistic that matters the most is, what is your record? I've never lost a jury trial, all of this sort of, I put them away. And in fact, at least in some offices I know, it is thought to be career advancement to go from the lower crimes to the higher crimes. And like the thing to do is get the big fish, right? I mean, just the big swinging hammer is, I'm wondering if you think it's realistic for prosecutors to spend time as defense attorneys. I think it's I hadn't heard it before. It's an innovative proposal. I take it you say it's done elsewhere. Could you say a little bit more about how you think that would work and why you think that might change views?
Yeah. So I think it's a little strong to talk about a prosecutorial culture. I think what happens is this. Most people who are prosecutors were not ever criminal defense lawyers. They're usually fairly young. They maybe spent a couple of years in a law firm and then joined the U.S. Attorney's Office or the DA's office or whatever. And they're only hearing, like all adversaries in our adversarial system, they're hearing mostly from one side. And in the criminal system, that's even more so, because until the case goes to a complaint or an indictment, they're only hearing in the great majority of cases from the police or the agents. And so they're hearing just one side of the case. And so, to take my example of eyewitness identification problems, what they're being told is, hey, we've got an eyewitness who says absolutely it's Joe Smith who committed the crime. And they never think to ask, was that a questionable eyewitness identification, not because the guy's a liar, but because of these frailties that I described before. And because they're young, they're also full of energy. Yes, they like to have good records and move on up. I lost my first trial as a prosecutor, but I, overcame that. I didn't cry for more than 2 months or so. My proposal is that out of every 3 years, prosecutors spend 6 months defending indigent defendants in another district where there would be no conflicts. Now, avoiding the conflicts would be the hardest part of it. Where the system in effect is in place is in England, where a barrister regularly represents the Crown in one case, and in the very next case represents the defendant in a criminal prosecution. But that's because barristers are given a file produced by the solicitors, by the lawyers who do the actual investigation and get it from the police and other investigators on the defense side. And So they just have to try the case. In the American system, the prosecutors play a bigger role in the investigatory part of the case. So you'd have to go to a greater lengths to make sure there were no conflicts, but I think it can be done. The results, I think, would be quite significant, because once you start looking at a case from both sides, once you're aware, as most defense counsel are, about how things can be distorted, how there are two sides to each story, once you're aware of all the nuances that a judge ideally becomes aware of, but that in a system where the power is now with the prosecutors, the balance doesn't prevail. Once you become aware of those balances, I think prosecutors would be a lot fairer.
Yeah, I mean, it raises another question that actually comes from one of our students, Alex Olakovsky. So Alex wanted to know what advice you have for those beginning their legal careers. And you've just discussed, different paths people could go, and ask what actions can we take as law students or new lawyers to help right these inequalities. Now, I'm curious about what your answer is to that, because you've given us different paths to consider: prosecution, defense. Later, you talk about the importance of legislators, and of course, there's the bench. So, wondering what your thoughts are, advice for our students as they begin to think about their careers in these fields.
So, well, self-evidently, the first thing they should do is clerk. And in all seriousness, clerking, which not everyone can afford to do, but will give you a more balanced sense of what the system is all about. You'll see it from the inside. So I think that is very valuable. But I think if you're going into the criminal justice system, it is probably best to start out as a prosecutor, because that is where the power / responsibility is presently located. And the point is not to stay there forever. And most prosecutors don't stay forever. I do think one thing that's on the defense side very unfortunate is many defense organizations, legal aid in many states, will not take former prosecutors into their office. They think they are ideologically suspect or just too inclined to get along with their former colleagues or whatever. I think that's a serious disservice to their clients. Former prosecutors are in the best position to know how to manipulate the system, for lack of a better word, to get a good result, if the plea bargain is the way you're going to go. Having said all of that, I think the real key is to find a way to be on both sides. When I was in private practice, I sometimes represented, in my civil cases, plaintiffs. I sometimes represented defendants. And I thought that was invaluable. It made me a much better lawyer. I'm sorry that there are not more criminal defense lawyers on the federal bench. There are many, many more people who just had prosecutorial background. But the ideal, I would say, in a self-serving way, is to have both. So that is my ultimate advice. If you really want to be an effective lawyer and a balanced lawyer, make sure you try cases and take cases from both sides, from each side.
Let me talk a little bit about, you've kind of referenced indirectly the adversarial process. I mean, so deep that even a dip in one office could taint you. Some view, and I've seen that as well. I agree that it's unfortunate. We see a lot of this adversary in the battle of the experts, and you write in the book about forensic science. And this is, as you know, an issue that's near and dear to my heart. I spend a lot of time thinking about it. I want to ask you, and you've emphasized that you said they are all fixable, these problems. But I want to push a little bit on the forensic evidence because you reference, and for those who know, there's a very important 2009 report from the National Academies, which, as you talk about, Judge Rakoff basically said, this body of evidence is problematic, and so is this, and fingerprints and bite marks, and on down the line. And there was some thought, I think, by scholars and others in the practitioners that this was combined with Daubert. For those who don't know, Daubert, again, it's written very clearly about in the book, is the new federal standard for admissibility of expert evidence, which empowered judges as gatekeepers to keep the bad science out and let the good science in, roughly. So the thought was, okay, judges are gatekeepers and they've got this power, and here comes the National Academies, right, the smartest people in the land, and they've just given us kind of the game plan for which is the better science and which is the worse, and by the way, a path forward for testing as to whether or not a science is actually useful. And yet, here is what one of our law professor colleagues, Julie Seaman, who's at Emory, wrote. She wrote, "One might wonder whether the 2009 publication of the NAS report on forensics, which highlights, among other things, the serious lack of data underlying many of the claims of forensic science, has had any effect on admissibility of such testimony." This was writing in 2013. I think it's still true. Her answer, the short answer, is that so far it has not. And she goes on to suggest that prosecutors in court seem to continue to be reluctant to engage in any serious examination of the reliability of the various types of evidence in that NAS report. And one of our attendees today, attorney Barry Edwards, echoes that. Here's what he wrote, what he writes. "I'm a public defender, tried lots of criminal cases. I have never succeeded keeping comparative forensics out of court, hair, firearm. And in Minnesota, we can't even get a cautionary instruction about eyewitness memory, nor did the DOJ make any changes after," and you referenced this particular report, PCAST report. So Attorney Edwards' question is, how can we get judges to respond to the actual science? And that's my question too. Is this really fixable? If the National Academies has done all the work, Daubert would seem to empower judges, and yet a decade, 2 decades later, this evidence still is routinely not just getting in, but not even being scrutinized in the ways that at least some of us hoped it would be. Could you talk a little bit about forensics?
Yeah. So first, the best solution, which was recommended by the 2009 report, was the creation of a National Institute of Forensic Science, staffed by nationally renowned people who would say, this forensic science is good, this forensic science is bad, this forensic science can be improved, and here's how. That's still the best solution. It never got political traction, and one can only speculate why, but I think a major reason is that most forensic science is in the hands of local police labs, where there is a very close connection between the police, the forensics science lab, and the political establishment in that particular community. That's not true everywhere, but it is true in the great majority of locations. And those people have a very strong vested interest in maintaining the status quo. But I do think the National Academy solution is still the best solution. Short of that, if you look at how Daubert has played out, it has been actually quite successful in civil cases, but very little so in criminal cases. And why is that? One reason is because in civil cases, you have people on both sides who can supply the best experts, who have the financial wherewithal frequently to employ experts. And so the Daubert hearings are much more meaningful. But a second reason is because both in the state and federal system, most of the judges who have any criminal background have primarily been prosecutors. And they're, oh yeah, hair match? Oh yeah, I used to do that all the time. Of course I'm going to let that in. That is what they are thinking. Now, having said that, the defense bar also bears some of this responsibility. It wasn't until like the last 10 years that I even saw a defense counsel raising a Daubert challenge. Many times I was thinking to myself, gee, I wish that they would raise the Daubert challenge, because I'm sort of into this stuff and it would be pretty interesting. But they didn't. And, under our system, I'm not at liberty to then say, well, let's have a Daubert challenge anyway. But that has begun to change. And with it, there has begun to change some of the judicial responses, even in criminal cases. I was just reading this morning a decision by Judge Lefkoe of the Northern District of Illinois, an excellent judge, where she kept out cell phone tower evidence. This is something that has become very popular in recent years. I've seen it several times in my court, where the theory is you can determine where the defendant was at a given time if you place the call, because the call will be picked up by the nearest tower. But in fact, the calls frequently will be picked up not by the nearest tower, but by several towers removed, because the way the technology works is if a tower is full, then your call isn't stopped, it's flipped over to the next tower, and so forth. More importantly, much of the, as Judge Lefkoe points out, much of the methodology behind cell phone tower testimony has never been tested scientifically. So it is open to a Daubert challenge. So I think there is beginning to be a shift as the defense counsel becomes more aware. I think there's also this, and I'm sorry to have to say this, but I think it's real true. In a criminal case, many judges will be thinking, gee, if I keep out that evidence, this guy who I think is guilty may not be convicted, because the defense counsel's yelling about where's the scientific evidence, where's the DNA, where's the hard stuff, not just the doubtful testimony of the cooperating witness. So in any close situation, I'm going to let it in. And then the weaknesses can be brought out in cross-examination, which, of course, Daubert points out is not a real solution. So I do think some of my colleagues, if there are any are listening to this, will probably string me up for saying this, but I do think there's that little bit feeling that you wouldn't have in a civil case where it's just money versus money. But in a criminal case, gee, the government has this high burden. I'm going to let it in and let the jury decide, even though I think there are some pretty good arguments for keeping it out. That's not true to the philosophy of Daubert, but I think that goes on.
Well, I have heard from many of my judge colleagues that, not necessarily in this context, but generally, the concern about being in the headlines, especially at the trial court level, as the judge who let so-and-so go free or back into society if it's some sort of probation, and if something, God forbid, goes wrong, that is a serious concern, and understandably so. But a driver. While we're on this point, for our colleague and joint friend here, Professor Claire Hill, who, thank you, Professor Hill, for really facilitating this event, and to your center. Here's her question, which is related to Daubert. She says that when she looks at the evidence, bite mark, blood spatter, and so forth, it seems useless and worse. So she's completely convinced. But does public opinion matter? Is it coming around, given this view of accumulating evidence? And would it be worthwhile, if it's not already there, to get public opinion to come around? And I want to connect that actually to a question, and I think maybe a tension that I read in the book, which is, throughout the book, there is a theme, which I really like, that judges are empowered. They have this ability. They should do more. And then there's this little 2-page coda at the end, where you say that the most sweeping solutions must come from the legislatures, and legislatures will not act unless they are pushed in that direction by the voters. So I guess, to Professor Hill's question, how much of, say, in the area of forensic, does the change have to sort of bubble up from a community that's ready to say, okay, forget the movies, I'm ready for a trial where we don't use fingerprint evidence, or don't use it in the way that we're used to?
So the way this works in real life is when there's a scandal. So in Houston, there was a huge scandal about a decade or so ago, when a examiner in the police lab there, the lab that was the forensic lab, but was not at all independent of the police, admitted ultimately to falsifying forensic evidence in like 100 cases. And these were like murder cases, rape cases, very serious felonies. And then there was a huge outcry, and Houston closed down the police lab and created an independent medical examiner's office, which is a model, is considered one of the best in the United States. But it took that kind of scandal to bring it about. Now, I will say an area where I think the public opinion has been moving in the right direction is with respect to mandatory minimums and career offender statutes. And they are the main cause of mass incarceration. So the ultimate fix there is to do away with those laws and go back to the much less harsh and much less mandatory laws that existed for most of this country's history. In 2018, there was enacted something called the First Step Act, which modestly modified some federal mandatory minimums. That was passed with bipartisan support, signed by President Trump, and reflected the fact that there really had been a growing recognition that this was a major cause of mass incarceration, and unfairly so. And now, the bad news, it was called the First Step Act. Where's the second act? Where's the second step? Where's the third step? Mm-hmm. And I'm afraid that will be affected by crime rates. Crime rates, one of the reasons I think the First Step Act could be passed without political danger was that crime rates were going down and down and down. This past year, although property crime rates still continue to go down, violent crime rates went up. Now, nothing like they were in the 70s, 80s, or 90s, but still, it was an increase. I'm hoping that that's just a pandemic blip. It's a reaction to the great stresses of the pandemic. But if it's more than that, then I think it will be very hard to make those kind of political changes that are really, in my view, as you say, the best solution.
I'm glad you mentioned the mandatory minimums. It's something I wanted to reach. As you know, the University of Minnesota Law School is the home of sentencing analysis, criminal sentencing, and sentencing guidelines. And my colleagues here, Professor Fray and Professor Wright, Professor Tonry, and others have really played such an important role nationally in developing guidelines and here in the state. And yet, those guidelines.
I thought Minnesota was mostly known for its law and neuroscience.
Oh, it will be. We're good. We'll get to that as well, for sure. You write about the tension between guidelines and more judicial discretion. Again, for those in the audience who haven't read it or come to it yet, the concern with allowing judges to just sort of sentence individually is that you get great disparities, and that two people for the same crime in two courtrooms could get very different sentences, and the data suggested those sentences were related to the defendant's race and other characteristics. So that was a real problem. The guidelines provide uniformity, but the guidelines, in my view, I think the view of many critics, at least as they were developed and are implemented, are so rigid, and of course they're constrained by these mandatory minimums, that they are uniformly bad, in my view, or at least uniformly ratcheted up. But if we were to replace them, my question is whether, again, you're the perfect person to answer this because you've seen, both systems. How much discretion should judges have at sentencing? And if they were different guidelines or revised, or if you had a hand in making those guidelines, how much should guidelines matter? Where should that pendulum lie between more individual discretion for the judge and much more constrained decision-making from sentencing guidelines?
So I'll start with the fact that I agree with you. The guidelines are in their present form without any redemption. In my view, they're totally irrational. And I'll give you an example, which is because they are arithmetic, they tend to focus on things that can be measured. So in drug cases, which are 40% of the federal criminal docket, it is the weight of the drugs that were distributed that is 70% of the guideline calculation. This can lead to incredibly mistaken results, because a typical federal drug case will have like 10 people. And up at the top is the kingpin, down at the bottom is a courier or someone who distributed maybe a few grams of cocaine. But under conspiracy law and under the guidelines, they will all be charged with the full weight, the many kilos that the conspiracy as a whole distributed, and that will put them up at 20 years, 30 years. The guidelines there are even higher than the mandatory minimums. The same thing in white-collar crimes. In white-collar crimes, what's easiest to measure? The amount of the loss. So that accounts for 70% of the calculation of the guidelines. I had a case called Adelson some years ago where the defendant was a relatively minor player, but it was a big stock fraud. It's a $50 million fraud. His guideline score was life imprisonment. Now, fortunately, he had me for the judge, so I gave him 3.5 years. But they're just off the wall. Now, so how do we deal with disparities? Oh, I should say two other things. First, the guidelines have racial disparities that are much worse than those that existed under the non-guideline system. The most obvious case was, and still is in some respects, the cocaine crack multiplier. So crack cocaine, which is basically baked powder cocaine, is chemically undifferent from powder cocaine. But because of perceptions that had little or no scientific validity, that it leads to greater violence, mainly arising from the fact that it was mostly used in Black communities where the violence rate overall was higher. The guidelines, in their wisdom, initially said that 1 gram of crack cocaine should be treated for guideline purposes as the equivalent of 100 grams of powder cocaine. So the sentences for crack cocaine distribution were huge, were off the wall, even when relatively small amounts were involved. Finally, this got to the point where Congress amended it, and the present ratio is 18-1. Where did they get 18? My guess is they were counting on their fingers and toes, but gave up after 18. But it has no scientific validity whatsoever. It is still, I refuse to enforce it. It's 1-1 in my courtroom, but it operates in a clearly invidious racial way, because most crack cocaine cases involve persons of color, and most powder cocaines involve a larger number of persons who are white. The one other point I want to make, and then get to your ultimate question of how to fix it, is the point I sort of alluded to earlier. Because so much of the system is now plea bargain, there are huge disparities between hard-nosed prosecutors and softer prosecutors, but no one knows about that because it's all something that's worked out in a secret plea bargain in the back room. And so you don't have the data that you would have in the old days of judges' sentences. Now, having said that, yes, there were soft judges and hard judges in the old days, and that sometimes was irrational and sometimes was racially discriminatory. To my mind, the best solution was the one that was passed, but it was passed along with the guidelines, and that was that either side can appeal the sentence. Mm-hmm. And I'm all for that. In the old days, you couldn't appeal the sentence except in very rare circumstances. Now you can appeal. And so I don't think we need the guidelines. I think if a judge is off the charts one way or the other, the Court of Appeals will look at it and say, no, you've gone too far in one direction or another. So will it be a perfect solution? No, but it'll be a lot better than having the guidelines.
Yeah, let me ask a related question. It comes from Dr. Eugene Borghita. Hi, Gene. Thanks for being here, our psychology professor and also affiliate professor of law and psychology. And he asks, how will we know which proposed changes and strategies are effective? What research is being proposed to determine efficacy? And I want to attach it to the conversation around sentencing guidelines. And this is related to sort of the intersection of science and law and neuroscience and law, where it strikes me as a concern that so much of the sentencing is, and the guidelines, the recommendations that come from a pre-sentence report for whether it's probation or parole or this or that, there is no outcome data. And sort of as an illustrative point, Judge Gertner, who I referenced before, is writing a book where she's trying to track down all of the men who are all Black and mostly young that she sentenced overly harshly, in her view, to find out sort of what happened, what was their story. And it strikes me that there's no feedback loop on whether what's better, 5 years or 7 years, this program or that program. I'm wondering if you could say a little bit about Dr. Borghita's question about how will we know if any of these interventions works, and what do we already know about what is or isn't working?
So there is, the Sentencing Commission does maintain some data along those lines for federal convictions and post-conviction behavior. But remember, the federal system is a tiny fraction of the criminal justice system. Well over 90% of criminal cases are brought in the states. and there's no comparable data that I'm aware of for the states. But once again, I worry a little bit about be careful what you wish for in this sense. The main effort that has been done in the states to assess likely recidivism is the use of algorithmic measures that have proven to be, in many respects, a disaster. Why are they a disaster? First, because they haven't been scientifically tested, the Dalbert type of issue. The few studies that have been done suggest they have a 30% error. Second, the way they arrive at their measurement of recidivism is by looking at inputs that they choose, which are often racially biased. So if you take, for example, the fact that 40% of the people in prison right now are young Black Americans, if you fed that without thinking about it into your algorithm, you're going to say, oh, he's a young Black American. Of course he's going to commit a new crime. I mean, really absurd things like that. Thirdly, because most of these algorithmic programs are privately produced, they keep the nature of the algorithms largely secret as a, quote, competitive trade secret. So you can't even test it very easily. And there is a case out of Michigan. You may have heard of Michigan. It's somewhere near Minnesota. That they call Loomis, which is a very unfortunate case. It says this algorithm was used to lengthen considerably the sentence imposed in this case, and the judge said as much. But we're not going to allow it to be tested, or we're affirming the failure of the trial court to allow it to be tested because, it's better than nothing, or words to that effect. And it's not better than nothing. It's dangerous. So outcome determination is very important. I'm very glad that Nancy Gertner was a great judge and a great person is working on that. But you have to be careful how you use it. This much more guideline-like use for increasing sentences through incapacitation on the claim that they are preventing future recidivism is, I think, very dangerous.
I agree with you, and it's interesting to see that sort of rapid development of some of these technologies and algorithms. Just sort of maybe one more question on this. We've talked a little bit about it already, but there are a couple of questions in the chat about the system and the role of district attorneys, and you talk a lot about that in terms of the power that they have at plea bargaining and at other points. And yet we haven't talked about this other part. We've talked about why the innocent plead guilty, but not really why the guilty go free. And so I'd like to make sure we get to that. You've got a couple of really wonderful chapters in the book talking about in various financial crimes where there is this deferred prosecution, basically a deal that says, clean up your act a little bit, pay a bunch of money, and there's not an individual that's going to have to spend time physically behind bars. I'm wondering what you think about this question of, is that a question of DA attitude? Where is that coming from? Because it does seem a little inconsistent with the overall sense of getting guilty verdicts, and this, how do we understand those twin, somewhat competing instincts to at least over prosecute here, but under prosecute over there?
So most of the impetus for this has come from the federal government, and that's because when you're talking about big financial crimes, it's usually the federal government that's in the best position to investigate. And there was this big shift. And it came about originally because of lack of resources. For example, the FBI prior to 9/11 had 1,000 agents working on white-collar crimes. After 9/11, almost all of them were shifted to anti-terrorism work. That makes perfect sense. But they didn't do what they maybe should have done and go out and hire another 1,000 to replace them. So it is so much easier / resource saving to go after the company than to go after the individuals. When I had the privilege of being chief of fraud prosecutions in the Southern District of New York for several years, and when I would assign, when those were in the days when we went after the high-level individuals, but when I would assign one of those cases to one of my prosecutors, I always had to say to that person, this is going to take you 3 years, and in the end, you may find doesn't go much higher than what we already know, the low-level person that got us first interested in this case, or it may go very high. We just don't know, and you got to be very careful. We can't have scapegoats just because this turned out to be a big crime. So some of those cases did go nowhere, but some of them really went far. All of that was required a lot of time, a lot of resources. It may have been one assistant, but it was like 5 agents, 7, as if the case got bigger, so did the number of agents. There were dozens of millions of documents usually, and now billions of emails on top of that. So it's so much easier to just go after the company. Now, of course, that has collateral consequences, and that's why the Justice Department is favorable, or has been at times favorable, to deferred prosecutions, because then you don't put the company out of business. You're just saying, keep your nose clean, and if you do that for 3 years, then we won't even prosecute at all, or we'll drop the case. And that's brought on by the irony that going after the corporation can harm a lot of innocent people. And prosecutors sensitive to that said, okay, we'll find this other way around that. But none of that addresses the fact that who committed these crimes? It was, in many, many cases, the high-level executives. There is a suggestion, there's a terrific book, but I don't fully agree with it in all respects, by Jesse Eisinger, called The Chicken Shit Club, in which he thinks that it's partly a revolving door problem. High-level prosecutors, not at the lower level, but high-level prosecutors are people who've usually, yes, they were AUSAs back when, but then they went to big firms. They were representing corporations. They became very sensitive to the arguments that companies would make. They came on and became, head of the Department of Justice or head of the criminal division. And they said they were, in his view, much too open to arguments about, you can't really go after those high-level people. They didn't really have criminal intent. I don't think I think there's a little something to that, but I think it is much more that you can save resources and get substantial political impact with these big announcements. Today, we find Bank of so-and-so, $5 billion. That sounds pretty good. But it doesn't achieve the deterrent effect that you had hoped to achieve.
We are. Thank you for those comments. I want to zoom out here in our last sort of 10 minutes to systemic effects and systemic reforms. And one of the things that it comes up in the book, and it's come up in our conversation, are that there are a lot of differences of opinion, of course, across localities, across judges, even within the same jurisdiction. I'm wondering, and this will get to your chapter in law and neuroscience, so I just definitely want to reach it. And we had the pleasure of being in the MacArthur Law and Neuroscience Project together many moons ago, and are in deep agreement that a lot of the so-called neurotechnology is not so much science, but bunk.
The difference is you still look like you're 25.
The other difference is that there have been some cases where, and some outside of the decision, some programs that I think are increasingly in conversation with the mind sciences, and especially one of the areas is around mental health, not just substance use disorders, but so much of the criminal justice system, given that we don't have a separate robust system for handling mental disorders, and the longer history we don't have time to get into of deinstitutionalization. I'm wondering if you could just say a few words, maybe not about neuroscience specifically, but about this intersection of mental health, addiction, criminal justice. Every judge I talks to speaks to these issues appearing in their courtroom. We do a lot of trainings around that. Is there opportunity for potential sort of bipartisan, joint work around these issues around mental health and crime?
Yes, but with two caveats. The first is that we really don't have very good data, again, about how successful these programs have been. I always feel good when I say, Defendant Jones, instead of sending you to prison, I'm sending you to a mental health program. But I don't really know what effect that has had. There's debates within, of course, psychology as to what is most effective. There are those that think medications are really the most effective. And that raises all sorts of issues about whether a judge can order someone to take a medication against their will. And then there are others who think that long-term therapy is really, behavioral therapy is really more effective. But we just don't know, or at least I haven't seen good hard data on how the federal system programs are doing in that respect. So I don't think you're going to get a big consensus for enlarging those programs until you have more evidence that they are effective. And the second thing is, from the court standpoint, I think there is a history of the courts sometimes being too quick to embrace new mental sciences and therapies. And so you have the famous question of eugenics that led to 40,000 forced court-order sterilizations of women in the early decades of the 20th century, approved by no less than Oliver Wendell Holmes in the infamous case of Buck v. Bell. You have lobotomies that are now largely banned in most countries of the world, but won the Nobel Prize for the inventor of it, but left many people dead or as vegetables. I think there are dangers here that one has to be very careful before embracing the new science. The great thing about neuroscience is it's a harder science than much of what has occurred in the past. And so that gives me a great deal of hope for the future. But I think that it's not yet ready for courtroom use in most instances.
And in many instances, I completely agree. Be an interesting future to watch. I want to, maybe my last question, give you one reading of this book that some might offer, and then just ask you to respond. So, and it's actually sort of circling back to where Dean Jenkins started us today, as we sort of are shocked and horrified by the death of Dante Wright, another young African-American male right here in our metro area. And you have a book where it's the innocent plead guilty, and it's disproportionately people of color plead guilty and are mass incarcerated. The guilty go free, and it's disproportionately white and frankly white males who go free. And so one reading of the system is that, in fact, it is doing exactly what it is designed to do, which is to be systemically racist, to keep in place power structures that, despite efforts by many, have not been displaced. And I'm wondering if you could comment generally on this line of critique, that there is a deep structural inequity that is related to a deep structural racism that has to be uprooted from the system in order to really address its flaws, and then to tweak the various procedural points around plea bargaining and sentencing and the like. I wonder how you respond to that, line of critiques.
Well, I would say several things. First, racism has been the great stain on American society from hundreds of years back. But much as it still exists, much as it still plays a major role, including in the legal system, we have made progress, and and that suggests to me that the American public, when properly educated to a problem, can respond and can move forward, as they have, not nearly to the extent we would ideally like, but nevertheless to a very demonstrable extent. I remember visiting the South when I was a young kid. I grew up in Philadelphia, but my parents would take us on trips to like Virginia. It was shocking to me, even as a young kid, the separate bathrooms, the separate restaurants, the whole thing. I mean, so progress has been made, not nearly as much as we should. And there is, of course, the notion, I think well documented, of unconscious racism, which is harder to deal with than conscious racism. Having said that, to my mind, an equally major problem, and one that is truly as old as the hills, is economic disparity. And the poor get treated by the law, whether the legislative law or the law in the courts, much worse than the rich. And this has been so for a long time. But unlike racism, where at least we've seen some progress, here things seem to have gone in the other direction with ever greater economic disparity. So that in some ways worries me even more. There's a famous author, Anatole France, a century ago, who said, "Isn't the law great? In its majesty, it treats equally well rich and poor, and prosecutes equally those who steal a loaf of bread or sleep under a bridge." And the point is still, I think, well taken. It's the illusion of equality, but not the reality.
Yeah. Well, thank you, Judge Rakoff, for giving us the reality of the criminal justice system. The book, Why the Innocent Plead Guilty and the Guilty Go Free, available everywhere. I encourage you to read it. We didn't even get to the death penalty. I want to encourage everyone to read it. It's very touching and moving personal reflection from Judge Rakoff on that and many other topics. Thank you for joining us at the University of Minnesota Law School. To everyone listening, if your friends couldn't attend, you'll get a note. This has been recorded and we'll post it live. And again, thank you, Judge, for being with us. And this
My great pleasure. Thank you.
Concludes our program today. Thanks, everyone.